Your assets and your portfolio are at risk. And today we are going to talk about how to leverage the way that attorneys and creditors think to your advantage to get the best asset protection possible. Hey guys, my name is Jeff Cottle. I'm one of the senior attorneys at Anderson Business Advisors. And today I'm excited to talk with you about how to make sure that you get the best asset protection possible. And so we're going to talk about three key principles of asset protection. The first is we will talk about how plaintiffs' attorneys, personal injury attorneys, creditors think, the thought process that they engage in when determining whether to file a lawsuit or go after somebody or not. The second thing that we'll talk about then is why this factors into anonymity and why anonymity actually works so well in providing you asset protection. And then lastly, we will talk about not just why anonymity works, but how not all anonymity is created equal and how you can get protection in court in addition to being anonymous in order to make sure that you have, again, the very best protection possible. Let's dive right in. So when we talk about asset protection and making sure that you are protected from attorneys and from creditors, the first thing that we need to understand is how these attorneys and creditors think. Now, for better and for worse, in your case, for better, I am an attorney, and I was a litigator before I came here to Anderson Business Advisors. So I have a good idea of how these creditors and attorneys think when engaging in a lawsuit process. You see, the first question any attorney asks any new client or potential client when they walk into their office is not what you might think. I've asked many a client this, hey, what do you think a personal injury attorney asks their potential client when they come into the office? And I get a lot of good answers. I get a lot of answers around, oh, what damages can you prove? Or do you have any hospital bills? Or have you missed any work? Or what insurance do you have? And all of those things are really important factors. It's also true that those are not the number one factor. The number one factor and the first question that any attorney will ask their client when they come in is, who is the other party? Who are we thinking about suing today? And the reason for this is because attorneys, rightfully so to a certain degree, want to make money. And they want to make their clients money too, at least in theory. So they want to make sure that this lawsuit will be worth their time. I did this myself when I was a litigator. I remember, in fact, I had a client who had a slam dunk case, easy money, open and closed, one of the easiest cases I had ever seen. The problem? The other party was destitute, had no money. As you can imagine, it was a difficult conversation when I told this client, hey, you have every right to be upset and you have a great case, but I'm still not sure it's going to be worth your time filing the lawsuit. His response, of course, was, well, why not? And I said, because your supposed friend, in this case, here is destitute. There's a reason they stole your stuff and then sold it. It's because they have no money. And so even if we were to file a lawsuit, we would win. I felt very confident in that. But all you would get is my attorney bill, and the other person would not have the money to pay. And so attorneys have conversations like this with their clients all the time. And I think you can see that's not unreasonable, pardon the double negative. But unfortunately, in some corners of the law, that has been flipped on its head to now, if we have a potential client in our office and we ask, well, who's the other party? And they say it's another party who looks like they have money, that lawsuit is coming no matter what. Even if the attorney knows that this other person, or that this potential client, does not have a good case. Even if this attorney knows that they're just looking for a quick check from an insurance company, they're still going to do it because the other party has money. And this is why being anonymous matters so much. Let me illustrate it for you here with an example. And so when we're talking with a potential client here and the attorney asks that number one question of, okay, who's the other party? If we have a person as the other party who is potentially somebody who has no assets or who does not have any ability to make payments, then, like my story just there, the attorney is going to be turned off by this case. However, if we have a party, an opposing party, and it looks like this, we have somebody, we'll just use real estate as an example, but this is certainly not the only example, who has several investment properties and several rental properties, and they are all owned in this individual's personal name. Then we have trouble. And like I said, the odds are really good that that lawsuit is coming no matter what. And so what do we do then? This is where anonymity comes in, and why it's such a big key factor in asset protection is because it addresses that attorney and that creditor's first question. Who are we suing? If we have a bunch of real estate, let's say we have our investor here and they've got a bunch of properties up here. Like I said, if that investor owns those properties in their personal name, it makes them a target for lawsuits. Why? Because real estate records are public. Whenever you purchase a piece of real estate, that ownership is public record. And it's easy target for a plaintiff's attorney if they look you up online and they see you own 3, 4, 5, 6 properties on the county records. Well, they're licking their chops. They're saying, hey, this is a quick and easy paycheck because I know this other person can pay. What do we do then? Well, we say, hey, let's take your name off of the county records. Let's make you anonymous. And that's the first step that I tell any of my clients. The first thing that they need to do is be anonymous. Do not invest in your own personal name. So what do we do then? We put these properties into LLCs, nearly always. There are, like everything in the law, there are exceptions to this, right? But these properties will go into LLCs. So what we have then now is, very importantly, for this first question, for the way the plaintiffs, attorneys, and creditors think, for this first question, now we have an answer for them in the negative. You don't show up anywhere. You look like you don't have anything. Is the attorney going to want to sue somebody who does not have anything? No, of course not. What happens is you deed these properties out of your personal name into each of these individual LLCs. That way, the LLC shows up on the county records instead of you. And we have put a big blocker on that first step. And we say, nuh-uh, you cannot see. In this case, this plaintiff's attorney cannot see what you have, or this creditor cannot see what you have. It makes you an unattractive target. See, that's how we turn the tables. We say, okay, if you are just basing this lawsuit on whether the opposing party has money or not, we're going to make it look like you have no money and that you're not worth suing. And that in and of itself is already an excellent deterrent for lawsuits and for creditors. But we're not done. Like I said, not all anonymity is created equal. Some people will talk about trusts. Some people will talk about other things that will provide protection. LLCs are going to be our primary tool, though. Why? Because LLCs provide protection in court on top of being anonymous. So not only are you fending off attorneys who are just making their determination based on whether you have money or not, but if they decide to sue anyways, the LLC gives you protection in court. This is especially true for a Wyoming LLC. So what we do then is we say, hey, let's have a parent company in a state with good protection, like Wyoming, like Delaware, like Nevada. For our real estate, it's usually going to be Wyoming. So we'll say, hey, each one of these LLCs is owned by a Wyoming parent company. And this way, the Wyoming parent company gives additional anonymity. Sometimes LLC ownership records are made public in some states. In Wyoming, it's not. So if we have a state like, I'll use Texas as an example, where ownership records for LLCs are publicly available, well, we again turn the tables there and we say, hey, not only can you not look up who owns this property because the LLC name is there. Now you cannot see who owns that Texas LLC. Instead, who owns the Texas LLC listed on the county records there, or I should say on the Secretary of State records, pardon, in Texas, is that Wyoming LLC. And then Wyoming is completely anonymous. They do not list ownership records publicly because they don't have them. They don't ask. And so then you can own the Wyoming LLC, but nobody in the public knows it. And that way you deter lawsuits and you make sure that you have protection there. And not only that, but even if your anonymity is somehow blown or gone, or if that lawsuit comes anyways, the Wyoming LLC provides outstanding protection in court anyways. That does not allow anybody suing from the outside to take anything out of the Wyoming LLC, and does not allow anybody suing from the inside to pierce that veil and get to you. We'll talk about that in another video. But again, the key to asset protection is making sure that you can leverage how attorneys and creditors think to your advantage, and leverage anonymity in the right way to give you the best protection. Thank you so much for joining me. Hey guys, if you enjoyed this video, hit that like button, and also you'll see a link in the description to schedule a free strategy session with myself or one of our other expert strategists and attorneys to talk about your situation and how best to protect yourself, your family, and your legacy. Thank you, and we'll see you soon.